Hello everybody. Today we will be talking about chapter 6, which deals with registration of firms. We are still continuing the Indian Partnership Act. This chapter contains sections running from section 56 to section 71. The most important provisions of this chapter is the provision section 69, which talks about effect of non-registration of firms. The other sections are all hovering around the registration of the firm, then the changes that are supposed to be registered, etc. Section 69 is a very important section. So let us see what are these sections. Section 56 talks about the power of state government to exempt from application of this chapter. Section 57 talks about appointment of registrars, deputy and assistant registrars for the purpose of facilitating the process of registration of firms and also updating of the records. Then section 58 talks about application for registration, and section 59 talks about grant of registration. Section 60, 61 and 62 talk about recording of alterations, noting of closing and opening of branches, and changes in the names and addresses of the partners. Then section 63 talks about recording of changes in and the dissolution of the firm, partners if there is any change or reconstitution, etc. Then section 64 talks about the power of registrar to make rectification of mistakes, or for the firm to bring it to the notice of registrar for making the corrections in the recordings in the register and the statements. Then section 65 talks about the amendments to be made to the register by court orders. Then section 66, 67 and 68 talk about the allowing these records to be used for inspection by people, grant of copies, and the rules of evidence relating to this. So the filed documents and the statements and the register can be offered for inspection or granted copies, and they will serve as evidence for the purpose of the disputes relating to the firm or by the firm. Then section 69 is a very important section which talks about effect of non-registration. Then section 70 talks about penalty for furnishing false particulars. Then section 71 talks about power to make rules. So the provisions of the chapter may be exempted either for an entire state or for part of the state, and for this the exemption can be granted by the state government. Otherwise the provisions will be applicable. Then section 50, this is according to section 56. Then section 58 talks about application for registration. So what are the details that are supposed to be specified? We discussed these details while we were seeing the contents of a draft partnership deed. Then there is a provision relating to the certain names that cannot be used, and certain names if used, you have to seek the approval of state government before you use them as a part of the name. Then signature of the application for registration and what is the mechanism of verification that is prescribed by the rules. This is about say section 58. Then where do you submit this application for registration? For this purpose, the registrar of firms, assistant registrars, deputy registrars, etc., will be appointed by the state government, and specific jurisdictions and of their operation will be specified by the central government under section 57. Then subject to compliance with all the requirements, then section 59, registrar grants the certificate of registration. Then changes in the firm have to be notified by the partners through a statement. This is where you have to intimate the name, change of name or place of business under section 61. Then where there is a change in the constitution of the firm by addition, outgoing of partners, then conversion of a minor, admitting a minor who becomes a major, whether he agrees to become a partner or not. So that kind of changes in the constitution have to be reported. Then dissolution of the firm also has to be notified to the registrar of firms. Then the management of the registers and the statements is handled by the registrar. So the changes of name, place, etc. have to be notified for updating the register. Then if there are any mistakes, application for rectification has to be made, or the registrar himself, if he notices that there is an error, he can make the correction. Then wherever there are any courts orders necessitating changes in the register, those have to be carried out by the registrar. Then keeping open the register and documents filed for inspection is dealt with in section 66. Then furnishing these copies is provided for in section 67. Then section 69 talks about effect of non-registration. Then let us go through the sections in detail. First, section 56 talks about the power to exempt from application of this chapter. So, as I indicated, the state government of any state may, by notification in the official gazette, direct that the provisions of this chapter shall not apply to that state or to any part thereof specified in the notification. So, the state government can give a notification saying that for this particular part of the state, the provisions relating to registration are not applicable. Then it could also indicate that it is not applicable for the whole state, or it could, by default, it will be applicable to the state. That's the position as far as section 56 is concerned. Then, and one more thing, once there is an exemption, then the disqualifications that arise out of non-registration will not apply to those places. So that is an important aspect that has to be taken note of. Then appointment of registrars, the state government registrars, the state government may appoint registrar of firms for the purposes of this act and may define the areas within which they shall exercise their powers and perform their duties. So whenever any applications for registration, etc., has to be made, it has to be made to the registrar having jurisdiction over the place where the principal business of the firm is located or the places of business are located. So that is as far as the appointment of registrars. That is the institutional framework for enabling registration and updating the records relating to registration. Then every registrar shall be deemed to be a public servant within the meaning of section 21 of the IPC. So all the offenses against public servants or the protections that are available for the public servant will be operational, because the section says that registrars are also deemed to be public servants. Then section 58 talks about the application for registration. So a registration of the firm may be effected at any time by doing what? By making an application. What is the application? The application has to be by a statement in the prescribed form. Then how do you send this application? Sending it by post or delivering it to the registrar of the area in which the place of the business of the firm is situated or it is proposed to be situated. So at that place, you are either sending by post or you are delivering physically the statement in the prescribed form, accompanied by a prescribed fee. Then what are the things that have to be stated? Bare minimum of things that are supposed to be stated are the firm name, the place or principal place of business of the firm, the name of any other places where the firm carries on business or intends to carry on business, then the date when each partner joined the firm, because the disqualifications of non-registration, etc., will be or inability to file suit, etc., will be for the partners. At the time when they are filing or relating to a dispute where they are filing, they should be named in the firm as partners. Only then they will have the right to file a suit. So that's the reason why you need to record when the partners joined the firm, etc. Then the names and full and permanent addresses of the partners and the duration of the firm. So where the duration is there, it will have to be indicated, and if it continues beyond the duration, you know that under section 7 they will be treated as partnership by partnership at will. Then the statement shall be signed by all the partners or by their agents specially authorized in this behalf. So the persons signing the statement shall also verify it in the manner prescribed. So under the rules, what is the mechanism of verification will be prescribed by the state government under section 71, and those provisions will be applicable. Then a firm name shall not contain any of the following words, namely crown, emperor, empress, empire, imperial, king, queen, royal. These words should not be there, or any other words which are expressing or implying the sanction, approval, or patronage of government. So those words should not be a part of the firm name. However, where the state government signifies its consent to use of such words as the part of the firm name, it should do so by an order in writing. So if I want to have any of these names or any other names which indicate that there is a sanction, approval, or patronage of the government, so I will have to make an application to the state government. Then the state government has to give a consent saying that I have no objection in terms of this firm using this word as a part of its name, and this order has to be given in writing. So what are the, let us see some of the cases in this regard. If any partner refuses to sign the partnership deed, so at the first stage itself, if there is any disagreement in terms of signing the deed, the firm will be registered after removing the name of the partner who is refusing to sign the deed. Then requirement of registration is satisfied when the firm is registered and the names of all the partners are registered in the register of firms. So only when these two things are done, the requirement of registration will be fulfilled, and accordingly, the ability to sue of the partner or the firm will be arising out of that. So this is what has been indicated in Shah VLG Narsi versus Vasantara Umashankar Pandey. Then here, where the name of the partner is not shown in the register of the firm on the date of filing the suit of the partner on behalf of the firm is not maintainable. So that's the reason why I said that on the date when the dispute is there and the suit is being filed, on that day he should be appearing in the books of the register of firms as a partner. Only then he can file a suit on behalf of the firm, or if he is taking up against the partners, other partners, or against the third parties, then he will also have to be named in the register of firms. So that's the reason why there is a need for updation of the records whenever there is any change. Then this was indicated by the court in Gandhi and Co. versus Krishna Glass Private Limited, where only principal place of business is mentioned and not the branch. The suit was held maintainable because the jurisdiction is based on the place of business. So if branch is not necessary, that it should be maintained, it should be indicated. Then in a case of South India Textiles versus Government of India, the use of the word India was supposed to be the issue of dispute. So the application for registration of the firm was made with South India Textiles. Then it was returned with the direction to delete the word India from the name of the firm, stating that the word India is prohibited under the provisions of Emblems and Names Prevention of Improper Use Act 1950. So they went ahead and they indicated that you should make an application under section 58(3) asking the state government to give you a written order. So the representation was made and that was rejected by the state government. So the matter went to the court, and the court held that the mere use of the word India does not signify that there is either a sanction, approval, or patronage of the government. Then for using that word and giving permission, it was not necessary for them to make an application under section 58(3). They indicated that sanction of government in this particular case was redundant. Then there is no improper use of the word India in the name. So South India, in the name South India Textiles, and it does not offend the Emblems Act, nor does it offend section 58(3) of the Act. So the refusal of the state government to grant this permission or to register was an action in excess of power, and the registrar was directed to register the firm. So this was the case of South India Textiles versus Government of Andhra Pradesh. Then section 59 talks about grant of registration. So where the registrar is satisfied that the provisions of section 58 have been duly complied with. And what are those requirements? First, the statement is supposed to be made in the form prescribed. Then it has to be accompanied by the prescribed fee. It has to be made to the registrar having the jurisdiction over the place where the place of business of the company is located. Then it should contain the particulars that are indicated there. It should be signed by all the partners, and it should be tendered with the prescribed fee. So once these, and it should not have a name which is proscribed, or if you are using any of those names, then you should have a state government's approval, written order approving the use of that name. So only when all these requirements are duly complied with under section 58, then the registrar will record an entry of the statement in a register called the Register of Firms. And whatever statement has been issued, that will be filed in the records of the registrar, and the registrar issues a certificate of registration thereafter under his signature. And another requirement for registration is all the partners should have signed, or their authorized representatives should have signed the firm application or the statement. Then once you have registered, then changes that are supposed to be there, they have to be recorded. So recording, section 60 talks about recording of alterations in firm name and principal place of business. So when an alteration is made in the firm name or in the location of the principal place of business of the registered firm, a statement specifying the alteration may be sent to the registrar, accompanied by a prescribed fee and signed and verified in the manner required under section 58. So under section 658, all the partners or their duly authorized agents are supposed to sign, and they have to be verified under the in the manner as prescribed. So that way, wherever there is any change in the firm name or location of the principal business of the registered firm, the notice or a statement has to be sent specifying what is the alteration, and then a prescribed fee as decided by the state government has to be enclosed along with it. It should be signed and verified and then sent to the registrar. On receiving this, the registrar, if it is satisfied that the provisions of section 1 have been complied with, he shall amend the entry relating to the firm in the register of firms in accordance with the statement and shall file it along with the statement related to the firm filed under that section. Then if some case law, no time has been prescribed for filing. So the registrar cannot refuse to receive these kind of statements for recording the changes on the ground that there is a delay. Then there were amendments which indicated that the change has to be intimated within a particular time limit, and that was also not allowed by the courts. So in Sharat Kotak versus Ramniklal Mohanlal Chawda, it was held that failure to inform register does not amount to deregistration of the firm, but it only is a non-compliance for which there could be penalties. Then replacement of a dead partner with a new partner, which was the issue in this case, did not require re-registration of a firm. So it is not a mere change in constitution of the firm by an outgoing partner replaced by a new partner does not necessitate re-registration of the firm. It's a mere reconstitution of the firm. That is what was held. Then there is a case of Gwalior Oil Mills versus Supreme Industries. Here a registered firm was reconstituted and the application was filed with the registrar for recording the changes. Then the firm had a dispute with a third party in respect of a contract, and it filed a suit for breach of contract. And the suit was filed by a partner who was initially a partner in his individual capacity and later in the capacity of a karta of a Hindu undivided firm. So there is a change in a capacity and there was a reconstitution of the firm on this ground. So the registrar recorded the changes after the proceedings were instituted, but gave a retrospective effect of the from the date of reconstitution. So since there is no time limit that is prescribed and the firm continued to be a registered firm, though there is only a change where the capacity of the presence of a person is all that has changed and the intimation was given and subsequently backdatedly registered by the registrar, it was held that the firm never ceased to be a registered firm and the suit filed by such a partner was held to be maintainable. So this is Gwalior Oil Mills versus Supreme Industries Limited. Then noting of closing and opening of branches. So where a registered firm discontinues business at any place or begins to carry on business at any place, such place not being its principal place of business. So that is where there is a branch, where it relates to closing of branches or opening of branches. Any partner or agent of the firm may send intimation thereof to the register. So here it is not necessary that all the partners should be intimating. Where it is the principal place of business, then all the partners have to sign as if it is an application under section 58. But here any partner or the agent of the firm, it will suffice if any partner or his agent will send the intimation to the registrar, who shall make a note of, on receiving this intimation, the registrar will make a note of such intimation in the entry relating to the firm in the register of firms, and he will file the intimation along with the statement relating to the firm filed under section 59. So whatever particulars are there relating to the firm of registration, subsequent changes, etc., that record will be updated with the statement, and the register also will be updated. Then section 62 talks about noting of changes in the names and addresses of partners. So when any partner in a registered firm alters his name or his permanent address, an intimation of the alteration may be sent by any partner or agent of the firm. So it is not necessary that the same partner has to intimate. Any partner of the firm or agent of the firm can make an application for noting of these changes to the registrar, and the registrar will deal with it by incorporating the same in the register and also filing the statement along with the other statements under section 59. So this is as far as section 62 is concerned. Then section 63 is an important section where important changes in the constitution of the firm and the dissolution of the firm, and also the minor becoming a major and his choice, that will have to be recorded. So first, when any change occurs in the constitution of a registered firm with any incoming partner, so an incoming partner can come based on the consent of all the partners or in accordance with the contract. Then continuing partner. So who is this continuing partner where the constitution will be changed? It is a minor who will be admitted into the partnership. So he will not be a full-time partner, but he will be only a partner for the purpose of benefits that are there. But on attaining majority, he'll continue in the partnership till the time he gives a public notice of his intention to either continue or move out. Then outgoing partner, it could be outgoing because of retirement, because of expulsion. The other events of outgoing are your death, insolvency, etc. So, or when the registered firm is dissolved, any person who was a partner immediately before the dissolution or agent of any such partner or person specially authorized in this behalf may give a notice to registrar of such change or dissolution, specifying the date thereof. So, who are the persons who can give an intimation, give a notice relating to this? A partner immediately before the dissolution or the agent of any such partner, or if a person is specifically authorized for the purpose of making or sending this notice across to the registrar of the change of the constitution of the registered firm or of the dissolution of the firm, indicating the date of effect of these changes. Then the registrar will receive them, make a record of the notice in the entry relating to the firm in the register of firms, and file the notice along with the statement relating to the firm filed under section 59. So it's very important as far as the notice, because section 72 of the public notice indicates in case of registered firms that a notice has to be sent to registrar. Otherwise, you will be held liable for holding out. Then other two modes of notice also are supposed to be issued. It is not that you send to the registrar and it will be over. That was the case of Asiyamma versus case. In that it was there that they gave this notice, but that was not sufficient. You have to use the three modes of registration of issuing a public notice under 72 for registered firms, or two modes of public notice for an unregistered firm. So for a registered firm, this notice of recording changes is one important thing. The second thing is giving a notice in the official gazette, and the third thing is publishing the notice in a vernacular newspaper at the place where the place of business of the firm is located. So these mechanisms of notice is very important. Then recording of notice of a minor after majority. So where a minor who has been admitted to the benefits of partnership in a firm attains majority and elects to become or not to become a partner, and the firm is then a registered firm, he or his agent specially authorized in this behalf may give a notice to the registrar that he has or has not become a partner, and the registrar shall deal with the notice in the manner provided in subsection 1. So here, giving this notice within the period of 6 months of attaining majority or getting to know about being admitted to the benefits of the partnership firm is a very important requisite under section 30 of the Indian Partnership Act. So in case the notice is not given, the default option that is there is after the expiry of 6 months, automatically he will be made a partner. So this change of the decision of the minor has to be conveyed, for which there has to be a notice that has to be given to the registrar if it is a registered partnership. Otherwise, the other two modes of notices, what is important. So once the notice is received, then the registrar will deal with the notice in the manner that is, he will file that, he will record the changes in the register of the firms. So now section 64 talks, you have incorporated all the details, but it may so happen that there could be some mistakes which are there in the register. So at that stage, if the registrar notices it by himself, the registrar will have the power at all times to rectify any mistake in order to bring the entry in the register of firms relating to any firm into conformity with the documents related to that firm filed under this chapter. So you've seen that for every aspect of registration and changes that are supposed to be made, a statement is supposed to be filed. And based on this statement, the entries in the register will be made and it will be updated. So if there is any mismatch between the document and the entry, the registrar has power at any point of time to carry out those changes. Then where the parties notice that there is any change. So here on an application made by all the parties who have signed any document related to a firm filed under this chapter, the registrar may rectify any mistake in such document or in the record or note thereof made in the register of firms. So where there is an original document and that has been wrongly recorded, then all those parties who have filed those documents which they want to rectify, the entry in relation to which document they want to rectify, they will have to sign and make an application to the registrar, and then registrar will rectify the position in the document and also in the record and make a note of it in the register of firms. So sometimes it may so happen that the disputes land up in the court, and then court will have to give a direction whether the firm is a firm or whether the partner, the person is a partner or he is not a partner. So those changes that are necessitated by the court order have also to be carried out by the registrar. That is what is section 65. It says a court deciding any matter relating to a registered firm may direct that the registrar shall make any amendment in the entry in the register of firms relating to such firm which is consequential upon its decision, and the registrar shall amend the entry accordingly. So where the court directs saying that the minor has chosen not to be a partner, but after 6 months, someone has indicated that this man has been admitted to partnership because of the operation of that 6-month period. So then he goes to the court and he says that I have no notice. Now I am choosing not to be a part of this. Then the court will issue an order saying that yes, this minor will now no more be a partner because of his exercise of the choice. 6 months after he got to know about his being admitted. So that will be a change. Then someone has been expelled and they intimated the notice, but then the expulsion was not in accordance with the procedure that is provided for under the Partnership Act. It has not been, there is no clause of expulsion in the partnership agreement, or the expulsion has not, the power has not been exercised in good faith. So he goes to the court and says that they have wrongfully expelled me. Then the registrar has already intimated that he has been expelled. So then the court will indicate that no, that expulsion is wrong and set aside. So you have to modify the record so as to incorporate him back into the partners, names of the partners. So those changes consequent upon the court orders have to be carried out by the registrar. Then this is relating to the inspection of registers and filed documents. So the register of firms shall be open to inspection by any person on payment of such fee as may be prescribed. So if someone wants to know whether it's a registered firm or not for all the action that is supposed to be taken, etc., the register has to be kept open for inspection, and someone has to pay a fee prescribed and give an application to have access to the register. Then apart from that, all statements, notices, and intimations filed under this chapter shall also open to inspection, subject to such conditions and on payment of such fee as may be prescribed. So The statement, notices and intimations are the basis on which the register is updated, and you will get to know when that has been made, etc. So for that purpose, someone would want to have a look at them. So for that, what are the conditions based on which they will be given access to these statements, notices and intimations, and what is the payment of fee will be prescribed by the rules made by state government. Then grant of copies. So the registrar shall on application furnish to any person a copy certified under his hand of any entry or portion thereof in the register of firms on payment of such fee as may be prescribed. So someone wants to file a preliminary objection when a suit is filed, saying that this fellow is not there as a partner. So he is disqualified from filing a suit for enforcement of a contract. So then what he will want to show is the document relating to the register of firms to indicate that this fellow was not shown in the partners list. So how does he produce that? He will have to take a copy. And what will be the copy? A copy of the register and also a copy of the statement, depending upon whichever he wants to enclose along with this. What is it? Affidavit, or maybe the response that he wants to give a suit. So that certified copy of that document will have the can be produced. And how do you get that? You have to make an application, and you will have to indicate what is the detail that you want, then that you want to have a copy, and then you make a payment of the prescribed fee. Then the registrar will provide the copy of that entry. Then the fact that this register and other things are maintained in an appropriate manner, they will have evidentiary value. So that is what is the provisions of section 68. It says any statement, intimation or notice recorded or noted in the register of firms shall, as against any person by whom or on whose behalf such statement, intimation or notice was signed, be conclusive proof of any fact therein stated. So wherever there is any change in the firm, change in the name, change in the constitution, admission, or etc. So whatever statement, intimation or notice has been recorded will be conclusive proof of the fact relating to whatever is indicated in that. Then a certified copy of an entry relating to a firm in the register of firms may be produced in proof of the fact of the registration of the firm and contents of any statement, intimation or notice recorded or noted therein. So as I already indicated, you want to indicate that the firm is registered or not. So then you bring out a statement from a copy from the registrar saying that this firm is a registered firm or not. Then whether this partner is there or not, then the date when the partner was a partner or not, when he was expelled, etc. So those kind of details you need to have the registered documents and the copies required. And these certified copy which is provided by the registrar can be used as a evidence. Then so what has been held as sufficient evidence of partnership or the person being a partner, which is a requirement for filing a suit under filing a suit, so that the disqualification under section 69 will not apply. A copy of the register of firms, then a statement filed with the registrar of firms, then application form where the person's names and signature are appearing as a partner, then the plea that he was, when these details are there, the fact if someone is alleging that the person is shown only as nominally as a partner, has been held to be not tenable, because you don't have names just for the sake of being nominal. The fact that you are indicating these details under with the registrar of firms indicates that he is a partner of the firm. So that has been held in Shivaji Reddy versus and Brothers versus S. Raghurao Reddy. So it is not necessary that the certificate of registration or the partnership deed which are filed with the registrar are final, but they are held to be rebuttable evidence in some cases. So the certificate of registration issued by registrar of firms will be a proof, but if someone has any produces any evidence to rebut this, then it can be rebutted. Then similarly, a partnership deed to be filed with the registrar. So it is not necessary for the partnership to be in writing, as it is the case in English Partnership Act. In our case, it is not necessary. In English Partnership Act, it is necessary that it has to be registered. Registration is compulsory. then in our case, neither registration is compulsory nor having a partnership deed is compulsory. So the fact that a partnership deed has been registered with the registrar, it is a rebuttable evidence. This was held in case of Badiram versus RS Co. So now we come to the important section, which is section 69, which talks about effect of non-registration. So first section, there are two aspects that are there in this particular section. One is by a partner against the firm or other partners. So that is the first part. Then second thing is in relation to by a partner or firm against third parties. So first section talks about partner against the person who is a partner. So no suit to enforce a right arising from a contract or conferred by this act shall be instituted in any court by or on behalf of any person suing as a partner in a firm against the firm or any person alleged to be or to have been a partner in the firm, unless the firm is registered and the person suing is or has been shown in the register of firms as a partner in the firm. So if a person is to sue any other partner, or if he has to initiate any legal proceedings against the firm or any person alleged to have been a partner, the two requirements are necessary. One, the firm is to be registered, and second, the person suing has to be shown as a partner of the firm in the register of firms. So this section deals with suit to enforce right from a contract or from partnership. So for enforcing of a right under the contract or from the rights emanating from the Partnership Act. So for that purpose, if a suit has to be filed, so it has to be by a partner. It deals with a suit by a partner against the firm or a partner. So what are the mandatory requirements? As I told you, firm should be registered and the person suing is shown as a partner in the register of firms. So the provision has been incorporated basically to push partnership firms to get themselves registered and not mandate registration as it is provided for in the English Partnership Act. So but partners of unregistered firms cannot sue firm or present or past partners for enforcement of rights. Then have to register before suing, but disputing partners may not sign. So if he wants to file a suit, so he may want to register the partnership firm. So once I know that I want to now ask for registration, so it is indicated, it could be presumed by the partners now that this guy is now asking for a registration merely for taking up proceedings against us. So they will not sign the firm, sign the deed for registration of the firm. So the only option that is available for the partners of unregistered firm or partners who are not figuring in the register of firms is they are not qualified to take up a suit, but they are qualified to take up for dissolution of the firm and realization of their rights. So giving their portion, a settlement of accounts and dissolution of partnership is something for which they will continue to have a right. Then registration during the pendency of the suit. So if the disqualification is there, but the suit has not been either dismissed, so it is pending. At that stage, do I go and register, or I will get the firm, I will withdraw the petition, register the firm, and then again subsequently file the case after registration. So whether the limitation period will be extended for this, that there is no conclusive opinion by the courts. So basically, this provision is aimed at registering a firm after constitution and to ensure registrar as the holder of updated records of the firm for inspection or copy by anyone. So to know whether some partner has been there at that time or not, you need to go and have the access to the records, and you to know whether someone is a salaried partner or a employee. You have to see the partnership deed and whether he has signed in the registration deed, or subsequently his name has been mentioned as a partner in the amendment documents, etc. So those records need to be produced, and only then you will be in a position to have the suits filed. So suit is allowed where the partnership deed was altered and the altered deed was neither acted upon nor registered. So the suit could be filed based on the original registered deed. If that serves the purpose, then in accordance with that original registered deed, the suit can be filed. Then plaint was filed by authorized signatory of the firm who was not a partner but authorized by the partners. So here it was indicated that the plaint need not be signed by all the partners. So an authorized partner on behalf of the firm is sufficient to file the plaint. It is not necessary for all the partners in the cause title to be signing the plaint. Then suit was not allowed in the following cases. In case of an unregistered firm for enforcement of deed of an unregistered firm. So basically it is enforcement of a partnership deed is basically a contractual enforcement that is required under the agreement that is there. So if that has not been permitted because registration is compulsory for enforcement of a contract. Then similarly sued by minor beneficiaries against co-partners of an unregistered firm. So section 30 gives the right saying that if he is not paid the share or if he is not provided the accounts for asking for the accounts or for filing a suit for the share, he has a right to go and approach the court provided he will have to be discontinued. He has to be expressing an intention that he will not continue in the firm. So on that instance also you cannot do because the firm is not registered. So such minors right which is supposed to be exercised, that can also be not exercised because of the disqualification operating under section 65, because the right that is provided there is a right under section 30 that will also be not given. So section 69(1) talks about two rights: rights against the contract of the partnership itself. Then second, rights which are granted under the partnership by the Partnership Act, like right to be indemnified for the fraud or loss caused because of a partner. So someone has committed a fraud and he has taken away what is it, it has resulted in a loss to the firm. So now I want to be indemnified for the action that he has that partner has been done. I want to take up a suit against him. I can't do it if the firm is an unregistered firm. Then in case of a registered firm also, some instances where the suit was not allowed was where all partners presently in the firm are not shown. Then the plaint is signed by manager authorized by a partner, but that partner is not shown in the register of the firms. So at the time that the plaint is supposed to be filed, that partner should be there or was there. So at the relevant point of time, his name should be appearing. So that's the reason why any changes that are there have to be carried and got recorded in the register of the firms. Then change in constitution of firm not carried out in the register of firms. So all these instances, in spite of the firm being registered, if the records are not up to date, accordingly, the rights to sue will also be either provided or refused. Then when a suit is filed without registering the partnership, it is liable to be dismissed. So the defect cannot be rectified by subsequent registration. So these are the issues as far as section 69(1) is concerned. Then here, there was a case of P. Anandrao versus P. Gajarao, in which case the sons of partners became partners on devolution of interest on death, but they did not register the change. So as per the deed of partnership, a partner could only sell his interest to other partners. So they found that another partner sold his interest to an outside party. So the sons wanted to sue the partner for breach of contract or to enforce the partnership agreement. It was held that no suit can lie as the change of those partners filling in for their fathers has not been registered, and the firm became unregistered as far as the partners are concerned. So the request to allow enforcement as co-owners of property also was not accepted. So what you can't do as partners, you can't say now that I am going to be a co-owner, because we saw that there is a distinction between co-ownership and partnership. Mutual agency is an essential aspect, which is not there in co-ownership. So just because you are not permitted under partnership, you go and say that I am now a co-owner. That is not permitted. So the only option that was available for these partners was to sue for dissolution of firm and distribution of the property. In case of Ramavatar Surajmal Modi versus Banarsi Bai Mulchand Modi, where the dispute was related to original partnership which was registered, the court allowed a case to be filed, though the firm was reconstituted, and this reconstituted firm document was not registered. So where there is a document that is already in existence, so where the deed is in relation to the original partnership, that was allowed to be a suit was allowed in that respect of that case. Then the second thing is in relation to the third parties. The section 69(2) talks about the third party related enforcement of rights. So no suit to enforce a right arising from a contract shall be instituted in any court by or on behalf of a firm against any third party unless the firm is registered and the persons suing are or have been shown in the register of firms as partners in the firm. So here also it deals with suits to enforce a right arising from a contract. So I have sold something to a third party. So under the contract of sale, I have certain rights. So for enforcing that right against the third party, when can I enforce it? First, my firm has to be registered. Second, if I am going to file a suit, my name should be appearing as a partner in the register of partners, the register of firms as a partner. So only when these two are fulfilled, then only I can I can file a suit for taking up a matter relating to enforcement of contract against the third party. So the firm has to be registered and the person. So, however, where a third party is filing a case against the firm or a partner, then it is not necessary that the firm should be registered, etc. For defending a suit, these disqualifications under section 69 will not apply. But for filing suits, the disqualifications will apply. One, under subsection 1, for filing a suit by a partner against the partner or the firm. Subsection 2, by a partner against third party for enforcement of contract. Then cases of suit against third party not allowed or dismissed. So where specific performance of contract of an unregistered firm, it was not permitted because of the absence of registration of the firm. Then the constitution of the partners was changed by the partners, with the partners going out and coming in, and these changes were not registered. So the requirement is the partner who is filing the suit has to be named in the register of firms. So since that was not there, then the suit was not allowed. The name of one of the partners was not shown in the register of firms, in which case also it was disallowed. Then recovery of loan where names of two partners was not appearing in the register. So that's the reason why it's important that not only that you register the firm, but any changes in the constitution of the firm have also to be intimated to the registrar and noted in the register. Then partners changed in the register of firm after the decree was issued. So here the case was conducted and the decree was issued, but after the decree was issued, the partnership composition changed. So it was held that the benefit of the decree or liability of the partners was only to persons recorded as partners in the register as on the date of suit. So that's the reason why the dates are very, very material for any suits, either against the partners or the firm or against third parties or by the third parties as well. Then action of unregistered firm cannot be rectified by subsequent registration. So a fresh suit has to be filed after registration, and the limitation period, whichever is there, it has to be within the limitation period that is supposed to be there. Then plea for non-maintainability must be raised or taken up by the court at the first instance. So where there is a suit that is filed by a person against the partner or against the firm or against the third party, the first instance itself, the defense has to be taken, saying that the firm is unregistered or this person is not named in the register of firms. It cannot be raised subsequently at a later stage. Then disability of filing suit is applicable only for right arising from contract. So here the disability is only for right against the contract, arising from contract, but not for any other statutory right. So we'll see certain examples where the rights are not arising out of contract, but out of other rights. Example, a suit to evict a tenant. So the right to evict will be something where there is no payment of rent, default in payment of rent or not meeting the conditions of the tenancy. Under the Transfer of Property Act, you get the right. So you are not disqualified for enforcing this right because of the prohibition under section 69(1) or 2. That second, suit to prevent infringement of registered trademark. The right will be under the Trademarks Act, and for enforcing of that right, you can a suit will be permitted irrespective of whether the firm is registered or not, or the person filing this is a partner or not. Then suit to prevent misrepresentation of goods or services of others in case of unregistered trademarks, which is a passing of action in torts, that can be taken up. Then suit for recovery of damages for misconduct of partners, breaking open firms, go down, theft and damage to property, etc. So these are not basically contractual rights, but other statutory rights, because of which the disqualifications will not be applicable. However, section 69(2) will be applicable where there is discrepancy is there in the names appearing in the register of firms, because inclusion of new partners and the admission of minors of benefit and names of parties included in the suit, if there is a deviation in the names of the partners indicated in the suit and the constitution of the partnership firm because of addition of new partners, minor becoming accepting to be a partner, etc. In that case, the suit was held to be non-maintainable. This was in the case of Shriram Finance Corp versus Yasin Khan. So in other case where the plaint was originally filed by an unregistered firm, but then subsequently they found that there is a disqualification. So they transformed the plaint by changing the title and indicating all the firm partners as individuals, and then thought that they can take up the proceedings. Whereas in the plaint, it is indicated that the firm is the party who, in relation to which the proceedings are taken up. It was indicated that such an action cannot be maintainable. You can't replace the firm with the individual partners. So the only relief that can be provided for those cases is to go for dissolution of the firm. So this is what section 69(3) says. 69(3) says that the provisions of section 1 and 2 shall apply also to a claim of setting off or set off or other proceedings to enforce a right arising from a contract. So what is this setting off, set off? You are supposed to be, you owe some money, then the other party owes some money to you. So you are netting off the two, and then you are paying or you are receiving the amount which is there in the netted off amount. So that is also not permitted, is what section 69(3) says. Then any other proceedings to enforce the right arising from a contract. So arbitration is one of the mechanisms by which you can take up where there is a breach of contract, if it is provided for in the contract. So it has been held that you can't even take up arbitration proceedings because the disqualification can be sidestepped. Or in case you are allowing set off, then he is deriving a benefit in spite of being an unregistered entity. So that is not permissible, is what is the first part of section 69(3). However, this will not affect the enforcement of any right to sue for the dissolution of a firm or for accounts of a dissolved firm, or any right or power to realize the property of a dissolved firm, or the powers of an official assignee or receiver of court to realize the property of an insolvent partner under the Presidency Towns Insolvency Act or Provincial Insolvency Act 1920. So the option that is available is that there no recourse when the firm is not registered or the partners' names are not there. So the recourse available is that you can go in for dissolution of the firm and accounts of the dissolved firm, and then you can go and file a case for realizing the property of after the dissolution of the firm. Then in case the partner has become an insolvent, the powers of the official assignee or the receiver of the court will to receive or realize the property of an insolvent partner. that can also be enforced. So those provisions are not barred because of the operation of section 69(1) and 69(2). So here the claim of set off is that of netting of what is owed to the firm from what the firm owes. This claim also cannot be made in case of an unregistered firm. Then other proceedings. So here enforcement of arbitration proceedings in continuation with the clause in the partnership deed. Supreme Court in its judgment in Jagdish Chandra Gupta versus Kajaria Traders indicated that the right to arbitration proceedings is also not maintainable, because if this is permitted, whatever disability in the section 69(1) and 2 can be offset, and you can go and use the arbitration route and then get the arbitrations enforced according to the Arbitration and Conciliation Act. So that should not be permitted. However, in one particular case where the proceedings went further, there it was indicated that since the award was issued, etc., it was indicated that proceedings will be maintainable. That was in case of Kamal Pushp Enterprises versus DR Construction Company. So other proceedings by unregistered firm which were held not maintainable were this suit for dissolution of an illegal partnership. So where there is no partnership at all, where does the question of dissolution come into play? Then application for appointment of an arbitrator, which is in accordance with the arbitration clause, or that was also not permitted to be done. So non-registration, what are the exceptions? So unregistered firms can bring action for dissolution of the firm, accounts of dissolved firms, enforcing the right or realizing the property of the dissolved firms. So the disability to sue is only during the subsistence of the firm, and it is not applicable for the dissolution of the firm. In Maharashtra, they have brought out an amendment saying that even for an action of dissolution and settlement of accounts, it cannot be done it cannot be brought in case of registered firms. So this was struck down as arbitrary and unreasonable by the court in the case V. Subramanian versus Rajesh Raghavendra Rao. So it was indicated that Article 14, Article 19(1)(g) and Article 300(a) are impacted because of the amendment that has been made, and that amendment was struck down. Then action for recovery of insolvent share by official assignee, receiver of court in insolvency proceeding was held maintainable. Then so in case of non-registration, certain exceptions, some of the cases. So in S. Ahmed Khan versus Thurup Muhammad Hayat, a taxi was purchased and run by A and B through an unregistered partnership. So A, without B's consent, sold the taxi. So the action was filed by B to recover the share of sale proceeds. So the court held that this was maintainable as it was for realization of assets of a dissolved firm. And why did the court deem that this is dissolved? Because the firm was doing the business of taxi, running a taxi. So when the taxi has been sold, automatically the business is closed. And once that is closed, so it's merely a realization of assets after dissolution of the firm. So the prohibition of section 69 will not apply. That was what the court held. Then in Ramesh Kumar Bhalotia versus Lalit Kumar Bhalotia, a suit for declaration of shares of partners, a proper administration of firm, and for rendition of accounts without the prayer for dissolution was held not maintainable. So now they came out with another case praying for dissolution of the firm. So in that case, it was held that this new suit was not barred by res judicata because the cause of action in the subsequent one, which is for dissolution, is a different cause of action when compared to the previous one relating. It was basically for declaration, administration, and rendition of accounts. The latter one was for the dissolution of firm. So dissolution is permitted under section 69(3) and section 69(3), but the other suit relating to them is not maintainable because it is not registered. Certain areas where it was held that the suit is maintainable was a suit for damages for misconduct by one partner on another in an unregistered firm as it was for enforcing the claim for realization of assets. Then recourse to arbitration clause for dissolution where the unregistered partnership has been dissolved by consent. So where that has already been dissolved, how to distribute the money was the only issue that was there. So recourse to arbitration was permitted. Then similarly for interim relief under section 9 of the Arbitration Act for the protecting the interests, etc., or for legal representatives, etc. So those kind of section 9 relief, interim relief applications under in relation to those were accepted. Then suit for recovery of dues by sole remaining partner when others left the unregistered firm. So the moment the others left and it's only one person, it's no more a partnership firm. So the recovery of dues will be almost like a settlement after dissolution. So the court held that this kind of proceedings are maintainable. Then section 69(4) talks about this non-application of section 69 in certain cases. So the section shall not apply to partners, to firms or to partners in firms which have no place of business in the territories to which this act extends, or whose places of business in the said territories are situated in areas to which by notification under section 56 this chapter does not apply. So where the application of the act is not there to a particular territory, or where the place of business of the firm is situated in a place where the act extension of the act has been notified to be not applicable, then the disqualifications under section 69 1 2 should not be applicable in those places. So that is what the section says. Then to any suit or claim of set off not exceeding 100 rupees in value, which in presidency towns is not of the kind specified under section 19 of the Presidency Small Causes Court Act 1882, or outside the presidency's towns is not of a kind specified in second schedule to the Provincial Small Cause Courts Act. So basically, for a suit of small causes, this prohibition is not applicable. Then to any proceeding in execution or other proceedings incidental to or arising from such a suit or claim. So for 100 rupees and less, this is a claim or set off, the disqualification will not apply. Then there are certain examples where the statutory effect of non-registration will not be applicable. Is for statutory and non-contractual rights of unregistered firm are not affected by the disability. So in case if persons damages the property of the firm, for recovery of money in respect of those damages, it has been permitted that a suit will lie. Then for criminal proceedings for dishonor of check and payment, so because this is a statutory right under the provisions of Negotiable Instrument Act section 138, that has been allowed to be permitted. The suit was held to be lying. Then for loss of goods by carrier or loss of consignment by railways, here the right does not come because of the Contract or Partnership Act, but because of the statutory right as a bailee under section 180 of the Contract Act. Then for personal injunction to prevent passing off or infringement of trademark, because it's a Trademarks Act which will be applicable. Then enforcing tenancy rights or eviction of a tenant, because it's a right under the Transfer of Property Act. Then similarly for recovering possession of property, depending upon the kind of property, the provisions of Transfer of Property Act, etc., would be applicable. And those rights are not affected by the prohibition under section 69 1 and 2. So for being admitted into partnership by heir of a deceased partner, then for enforcing a contract against government by a sole managing partner when others had gone out. So now there is no more of a partnership that is there. Only one person is there, so it becomes a personal transaction. Then sued by co-owners of firm property allotted to partners on dissolution for disproportion in shares. So once the firm has been dissolved, so it's as good as individuals who are there. So if they become co-owners, they will be treated as co-owners. And if there is any dispute relating to the distribution of the firm property, then those matters can be entertained in spite of the effect of non-registration. Then Section 70 talks about penalty for furnishing false particulars. So any person who signs any statement, amending statement, notice or intimation under this chapter, which is containing particulars which he knows to be false or he does not believe it to be true, or containing particulars which he knows to be incomplete or does not believe to be complete. So if it's false or he does not believe it to be true, or if it is not complete, or if it is, if he believes that it is incomplete, in those cases, he will be punishable with a imprisonment which may extend to 3 months or fine or with both. So this is in order to ensure that the statements that are filed are filed properly and they don't miss out on something or they don't hide the truth or give false statements. Then Section 71 is a section which is giving the state government power to make rules. And how are the rules made? They are made by issuing of the rules by notifying in the official gazette, they become effective. And the rules are basically prescribing the fees. And what are the elements for which fees can be prescribed by state government through rules? One, the fees which should accompany the documents sent to the registrar of firms, or the fees which shall be payable for inspection of documents in the custody of the registrar, and then for getting the copies of register of firms. So what is the fee that is supposed to be levied is prescribed by the state government by notification in the official gazette. However, the maximum amount of fees, it should not be exceeding. The fees shall not exceed the maximum fees specified under Schedule 1 of the Partnership Act. Then the government can also, so the first component is relating to fees. The second component is in relation to various other items that are required for implementing the act. So what are those items where rules can be made? One, prescribing the form of statement submitted under Section 58 and the verification thereof for the purpose of registration. Then requiring statements, intimations, and notices under Section 60, 61, 62, and 63 to be in prescribed form and prescribing the form thereof. So these are those which are relating to notification of changes in the constitution, dissolution of the firm, then rectification of mistakes, etc. Then prescribing the form of register of firms and the mode in which entries relating to firms are to be made therein, and the mode in which entries are to be amended or notes made therein. So these mechanisms of maintenance of the register of firms, updating that and modifying that is what is provided, can be made by rules prescribed by central government. Then regulating the procedure of registrar when disputes arise. So in case there is an entry that is made, how the dispute is supposed to be resolved, that can be made by the specified by the rules made by state government. Then regulating the filing of documents received by the registrar. Then where inspection is supposed to be is asked for, what are the conditions subject to which inspection of the original documents will be permitted, that can be prescribed by rules. Then regulating the grant of copies. Then regulating the elimination of registers and documents, so preservation period, etc. Those can be specified by the rules. Then providing for maintenance and form of an index to the register of firms so as to access the records easily. Then generally to carry out the purposes of this chapter, the rules can be made. So then once the rules are made, they have to be notified. So all rules made under this section shall be subject to the condition of previous publication. That is, they have to be notified in the official gazette. Then every rule made by the state government under this section shall be laid as soon as it is made before the state legislature. So the rule making power is subject to the state legislature's concurrence. So just like in any other rules where they are laid before the House of Legislature, so they can be, if no objection is raised, they will continue to be applicable. If any objection is raised or modification is suggested, it will be modified. Or if it is annulled, it will be not deemed to be in existence. So that is the power to make rules, and this power in respect of Partnership Act registration related aspects is with the state government. So this is about the chapter relating to registration of firms. So thank you.